Hello, this is Antonio Gangale. This is part 2 of the United States of America versus Union Cheese, determining if the declarations within the case are untrue, inaccurate. So we'll see the findings of fact, which stated that defendant Dominic Gangale is the president, sole shareholder of Union Cheese, with responsibility for and authority over the management and day-to-day operations of Union Cheese. When Dominic Gangale is not present at the plant, defendant Annette Gangale assumes control of its operations. I believe there's issues with this paragraph. It states sole shareholder of Union Cheese Company. Is Dale M. Gangale a co-owner? And if she's a co-owner, whether she'd have interest in the case and were required to have notice. Additionally, you'll see then it says responsibility for and authority over the management and day-to-day operations. And how does it apply if she's a co-owner? Additionally, it says day-to-day operations of Union Cheese Company. So it's a very, I believe, vague paragraph, considering that they omitted Dale M. Gangale and Antonio Gangale. So again, I mentioned I was with the Food and Drug Administration nearly all the times while they were in the facility, and you'll note we will discover that they were in there, I believe it was 21 days. So there was significant time that I was with them. They clearly knew who I was. So I kept a few letters and things from the plant. You'll see 7191, and within this letter it says, Dear Dominic and Tony, I want to express my thanks for a wonderful tour of Union Cheese Company. Tony, you're nice to explain the operation. Here's a list. Says, Dominic, please give here's number 1, son. Thanks, Bob. Also notice that the U.S. Department of Agriculture had inspected the facility before the Food and Drug Administration, and that was for 2 days on 7/14 and 7/15, 1994, and surveyed it on 2/28 to 3/1 through 3/2, and at 3/2 I believe was only for like a couple hours in the beginning of the day. And I think they arrived a little late. So basically, 2 inspections, 2 days. So if you think of the amount of time one inspector was at the facility and the Food and Drug Administration that were there with 2 to 3 guys, and you'll see the dates that they were there, I believe it adds up to 21 days. So you consider all of the amount of time and observations would it be possible for the Food and Drug Administration not to know who I was, and at least some understanding the role within the company? And if you would further inquire, if they inquired, as how many times did they witness or observe Dominic and Annette within the cheese manufacturing plant? So clearly, I believe that these declarations that they put forth, that the FDA would have had to have known who I was. Would it be possible for them to not know who I was and to be omitted from this case? You'll see in this within that June 16th order that the judge will mention me within this as well. So let's get into some of the filings in the docket. I believe this is where the FDA and the Justice Department, or the U.S. attorneys, as well as the court, had knowledge of issues with this and intentionally chose to ignore these issues. So it appears the complaint was filed on April 7th, 1995. There'll be an answer to the complaint on 4/26. There'll be a defendant's motion to dismiss defendant Annette M. Gangale. That'll be on 5/11. There'll be a memorandum in opposition of defendants to the plaintiff's motion for preliminary injunction, again on 5/11. And the case management on 5/11 as well. And you'll see within the case management, the FDA will visit defendant's facility and reassess state of affairs. Parties will meet in conference to discuss settlement or consent. Plaintiff will make investigators available for deposition. Defendant will make proprietors, managers available for depositions by 5/25. Parties have agreed that formal written discovery requests do not appear necessary at this time, which I find inconceivable, considering that there would be an answer to the complaint on 4/26. So let's examine what this answer to the complaint for injunction. Answer paragraph 5, defendant admit Annette M. Gangale is an individual, is the daughter of Dominic F. Gangale, admit she's an employee of Union Cheese, but denies she is second in command at Union Cheese Company. Further states she is not an officer of the corporation and is not in charge of the firm when Mr. Gangale is absent. And that's a docket number 8. On docket 11, you'll see a motion to drop party. Defendant has moved the court in order in accord with Federal Rules of Civil Procedure 21, dropping the defendant Annette M. Gangale from this case. Within that, there's an affidavit of Dominic F. Gangale. Within that, it states Annette is a secretary and office manager. She is a salary employee and is not a plant manager. From time to time, she instructed to complete certain tasks. Docket 13. Memorandum in opposition to the motion preliminary injunction. Response to the plaintiff's introduction. The defendant had previously served and filed an answer to the complaint for the injunction. In addition, the defendants have filed their motion to dismiss Annette M. Gangale from the action, having been improperly named as a party. Here's docket 13. Here, the memorandum in opposition to the motion preliminary injunction. There's an affidavit of Dominic F. Gangale. Dominic F. Gangale, being duly sworn upon a personal knowledge, says the following. My name is Dominic F. Gangale. I am the president and chief executive officer of Union Cheese. Came directly involved in every facet of the company and making cheese until perhaps 1990. At that time, for personal reasons, I elected to take less active role in the day-to-day operations of the company. So this is within Exhibit 3 on docket 13. When we get to the docket 14, the case management, you'll see, so they have the discovery. The FDA will visit defendant's facility. And then discovery. Plaintiff will make investigators available for depositions, and defendant will make proprietors and managers available for depositions. So clearly the FDA and the Justice Department had the ability to examine what these declarations that were put before the court and to see the truthfulness of them, see if there's anything omitted or there's a misunderstanding or whatever the case. Rule 11 is representations to the court. So the U.S. attorneys here, by presenting to the court a pleading, written motion, or other papers, whether signed, filed, submitted, or later advocated to, the attorney or unrepresented party certified that to the best of the person's knowledge, information, and belief formed after an inquiry, reasonable under the circumstance. Here, a reasonable opportunity for further investigation or discovery. Clearly, they had the ability to examine these declarations or see if there's any issues with these declarations. Further, there's the requisites for a valid judgment. And before court properly undertake an adjudication, 3 requirements must be met. First, the person with interest are to be adjudicated must be given adequate notice of the proceedings and an opportunity to be heard. So clearly it would be critically important that the people with interest in the case must be given notice. Third, that the court must have authority to adjudicate the type of controversy presented to it. This authority in general refers to as subject matter jurisdiction. So knowing this information, wouldn't you depose the proprietors, the managers? The court gives you the opportunity to do this. Why wouldn't it be used? And here, proprietor, owner of a business. So did they have the ability to do depositions on my father, Dominic F., or my mother, Dale, as well as the managers? So all these individuals, and that they were within the facility for 3 days. All these opportunities to examine if these declarations are correct, and the requisites to have a valid judgment is, do they ignore this? Would it be inconceivable that they conducted a trial knowing that there's issues out there of such? So Rule 65, notice the court may issue a preliminary injunction only on notice to the adverse party. Was that done? Further, due process, the right to receive notice before the government deprives an individual of a protected interest is guaranteed along with the opportunity to be heard. Were those violated? Were the due process rights violated within this case? Candor to a tribunal. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to a tribunal by a lawyer. Failure to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosing to the opposing counsel. Offer evidence that the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer becomes to the knowledge of its falsity, the lawyer shall take reasonable remedial measures. So are there issues that these declarations are inaccurate and untrue? And here's where it gets very disturbing. So on docket 16, there's the plaintiff's memorandum in opposition to defendant's motion to drop. So this is coming after, it appears, the 3-day inspection and the opportunity to depose the proprietor and the managers. It appears within this motion, Annette moves the court for summary judgment under Rule 65C, Federal Rules of Procedure, through an affidavit of Dominic F. Gangale. He states that Annette M. Gangale has no oversight over with respect to the operations of Union Cheese Company and therefore should not be made individually responsible for compliance with any injunctive relief in which may be ordered by this court. The remaining paragraph seems to recapitulate the statements or the declarations by Marzilli. It appears that the Justice Department and the FDA and Mr. Marzilli did not examine or to see if there's any issues with the declarations that they put before the court. And I believe that there are major issues with that. And you'll see here it says, they reassert again, she is second in command at Union Cheese Company. She is active in authority over the management and day-to-day operations of Union Cheese Company, including the methods, manner, and conditions under which Union Cheese are manufactured, although she does not have a title. Again, I don't understand where this does not have a title. In multiple documents within this, which were prepared by the FDA, it appears that she did have a title, and which was a secretary. And she was not to interfere when it came to operations. With regard to the manufacturing, it's absolutely incorrect. And you'll see here, officials of the FDA during the course of 3 FDA inspections. So let's examine, and let me back up here. And it says, a declaration of Phillip is attached. So we want to examine Phil's declaration as well. The first thing you will notice that it's not dated and seems to present observations that were done several months before. So it appears that this is 8-month-old information. He never re-examined facts or whatnot, and an injunction is for future acts. So even if that he asserts within there, it wouldn't even demonstrate if those are true to that day. But we'll go further within this. Further, we'll notice that there's a declaration from, an affidavit from my father who would have direct hand knowledge and the source of the information. He would be the ultimate individual that would have knowledge. It would be my father and or my mother. So why he would believe he would have more knowledge than the source is beyond me. I can't see these very well. I observed the role of Annette in the day-to-day operations of Union Cheese Company. What exactly did he observe? And where was he when he observed those, would be my question. During the FDA inspection on September 29th, I think, to 30th, Dominic President and plant manager. Again, there's, I believe, issue with that of being asserting he was a plant manager. And here's the most intriguing. It says Annette was identified as the CEO, helping her father run the business in charge in his absence. That's just absolutely ludicrous. If you would inquire as to my sister's knowledge of the plant operations, I don't believe during her 4 years in college that she even worked at the facility. And during high school, I don't know if she had even a role during that. I don't believe she had any after-school jobs, and maybe sometimes in the summer. So very little knowledge of what transpires within the operations. And you would want to understand what would her knowledge be. I think for myself that the information that Phil put before the court. So for Phil to assert CEO just doesn't make any logical sense. Not only from what he alleges from individuals, I would think he would, since he's there and making observations, if I was driving back and forth investigating and having to put a declaration before a federal court on an issue of the declarations to drop an individual and understanding the particulars of what this declaration was for, I'd wonder if what I put before the court, if it made much sense. If I was questioning Phil, I would want to know explain where the layout of the office and see if she's in a CEO position or would even make logical sense in the physical sense. So this is a brief, rough floor plan of the office. Again, this is rough, not to scale, and may have some errors in it. I'm sure it has some errors, but roughly the layout of what the office was. So there was a front door and a back door here. And so you'll see when you walk in that there's a conference area, and you would see a desk here and two desks here. There would be a door office through there. There would be, here was the fax and files, and behind there was another desk. On the opposite end, there was another office, storage room, and whatnot. My father's office was over here, my office was over here, and Mark Richter. So within the EIR reports or these reports, they have Dominic is the owner or the president, the CEO, and myself over here. So on this table, you'd want to know is who was here, and here. And this would be where my mother had sat for 18 years. Or excuse me, so she would probably be in that desk for 15 or plus years. And when my sister started assisting, this would be my sister's desk, and this is Dottie's desk. My mother was starting to retire, so my sister would usually sit here when my mother wasn't there. So anyway, you'll see that it appears to be like a reception room. So it doesn't make any logical sense that a CEO would be reception area. That doesn't even have doors to the office. So it wouldn't make logical sense of the role, more or less, that she's in a reception position or clearly secretary. So even it'd be more, I think, interesting is if you would ask Phil or had depositions whose desk this would be or where the layout is he probably mistaken my mother's desk for where Annette sat. So it doesn't even appear that they had knowledge of my mother's existence, which is very concerning considering she's a co-owner. So we'll see here within Phil's declaration during the FDA inspection in UCH's on October 27th and 28th and November 7th. So you see October 28th, and she's mentioned as a secretary. November 7th, again here there's secretary. So within Phil's declaration, it's specifying that she's a secretary. So you'll see here giving instructions in charge of computer operations and finance. And we clearly know that it asserts that she was a secretary during this period. or within the paperwork that they have done. Here it says after the inspection from November 28th through December 14th. So right here, again, you'll see owner's daughter. Here, second in command, in charge when Dominic F is not there, although she has no title. Well, I don't understand these things where it says it has no title. It appears that they're putting secretary down. So are these declarations, are they describing someone that's in the office? And are they describing what my mother's duties were? And are they explaining that Dale is also a co-owner, and they're not mentioning even her in this process? So these declarations just seem very incorrect, and they're not dated, and they're 8 months old. So I don't know how they even are valid or they're even sufficient. Further is you'll notice that there's an affidavit from Mike, and so there's no mention of Antonio, myself, or Dale. There's nothing with Dale or Antonio, and they're not named within this litigation. So So when you want to examine the findings of fact within this June 16th order, here it states that Defendant Dominic Gangale, the president and sole shareholder, is my mother, co-owner. Here, responsibility for and authority over the management and the day-to-day operations. What do they mean by that? When Dominic Gangale is not present at the plant, Defendant Annette Gangale assumes control of its operations. Is that incorrect or inaccurate or whatnot? Dominic Gangale is semi-retired, spending approximately 40% of his time at the plant. Is it 40% at the plant or at the firm, or what are they? Are they universally using, interchanging those terms, or what do they mean by that? Did Annette Gangale and or Dominic Gangale, did they have direct knowledge of operations? Is their ability to testify on the matter? Mission statement of the Justice Department to ensure fair and impartial administration of justice for all Americans. Deprivation of rights under the color of law. Whoever, under color law, statute, ordinance, regulation, or custom, willfully subjects any person in a state, territory, commonwealth, possession, or district of depriving the rights, privileges under Section 242 makes it a crime for a person acting under the law to willfully deprive a person of rights or privileges protected by the Constitution or laws of the United States. So here's a certificate of service of who was served within this case. Candor to our tribunal, we went through this. Is there willful blindness? Is there deliberate failure to make a reasonable inquiry